a primer on contempt law. You might think that's a couple of famous rock stars. They look like imposters to me, I happen to know, but we should hold them in contempt. But what happens when the judge says, you know what, I understand your legal theories and that's all well and good, but Mr. Settler, you need to bring those assets back by next Tuesday or you're going to jail. What do you tell your client? Well, we tell our client, comply. Do everything that you can do to bring assets back by next Tuesday. If the judge in the black robe says, do this, you need to show good faith compliance. Otherwise, you're going to be subject to a charge of contempt. And here's how it works. In contempt law, impossibility of performance is a complete defense. Now, the second star here shows there's an exception, which is the self-created impossibility. Now, let's put some perspective on this. I create an ILIT, an irrevocable life insurance trust. I fund it on day one in a big way. The ILIT's going to buy a single premium policy or something like this. John's my trustee. I create the ILIT. I transfer a bunch of money to John. He buys the policy as trustee. A couple of years later, I'm sued in a case. A couple of years later, I lose the case. I suffer a judgment. I don't have a lot left, all the actions in the trust. And on whatever theory, the judge says, Engel, go to that trustee Garland and get the money back. What are you going to say?
My response is no.
So you'll take a bullet for me.
I'll take a bullet.
You're a good partner. And that's the idea. The idea is, I parted with that asset years earlier. It belongs to the trust. And this analysis, if it's done properly, and we have, by the way, never had a client go to jail for contempt of court. Maybe for other things, I don't know, but never for contempt of court. It's the same analysis. The trustee owns the money. Now, the self-created impossibility. Somebody may say, but Engel, you can't rely on the impossibility of performance defense because you created that ILIT. Does it make sense that I can go to jail for contempt of court or be fined for contempt of court because years earlier I created an ILIT and named John Garland as my trustee, and now he's saying, I can't give you, I'd like to help you out, and I don't want to see you go to jail, at least for that, but I can't give you the money back or I'll be sued by the trustees. Well, that's the point, is that you read a lot about the self-created impossibility, especially in the asset protection context. But the exception to the exception, which is the third star here, is that there has to be a link or nexus in time to the particular court order. In other words, I'm ordered to produce my documents. On my way to produce the documents, I stop at McDonald's, get an orange juice and an egg white McMuffin, which are really good. And then I pass by a Shredders or Us, and I have an urge. Everything's shredded. I go to court. I go, I can't produce anything. It's impossible. It's all shredded. I'm responsible for the impossibility. That's the self-created impossibility. Contrast that with, I have a business partner. We have a falling out. I'm very upset, in a fit of rage. I go to Shredders or Us. Everything is shredded. And 2 years later, I'm ordered to produce the documents. I can't because I dumped my files years earlier.
You created the impossibility.
Yes, I did. And there's no link or nexus in time to that court order. Right. Now, you can do two things. You can stop there, or you can say, or you can send in a question and say, all right, I'm from Missouri, show me. Well, page 26 is part of a transcript from a federal case involving a client of ours back a number of years ago at this point in time, 1995. And if you turn to D2, the quoted portion, bottom of page 26, it says, the judge says, I've reviewed the law regarding contempt and the standards that are required for me to hold Mr. X, not his real name, in contempt. That standard is clear and convincing proof, which means something more than preponderance of the evidence, but something less than absolute certainty. One thing I've learned a long time ago as a judge, you never order something you can't enforce. And if we order him to pay $1 million, I have to be assured that's a reasonable order. As a matter of fact, contempt law says that one should not issue orders that cannot be complied with. It's a violation of due process to issue orders that the respondent cannot comply with. I'd look pretty silly if I entered orders that couldn't be enforced. There's case law to the effect that if we issue a compliance order that the respondent does not have the ability to comply with, that's punishment and violation of due process. By putting him in prison, that doesn't compel compliance because he does not have the ability, apparently, to comply. The Asset Protection Planning Guide itself, it's my frame of reference. It has a very, very thorough chapter on contempt of court. A lot of cases are cited. If you wish, you can read what's in there and, as well, make decisions about impossibility of performance, the self-created impossibility, and the exception to the exception. Now, as we wind toward the 0 hour, we're about 3/4 of our way done, a little bit more. I mentioned earlier this idea of the self-settled trust. John's going to guide us through this discussion. Just as an introduction to that, once again, we have well, you're going to cover this. Go ahead.
Yeah, I'm going to cover this.
I'm going to step on your toes
Sure.
for a change.
Self-settled trust. What is a self-settled trust? Good to know. Easy concept. You create a trust, you fund it, and you're a beneficiary of the trust yourself. Are self-settled trusts valid trusts? Well, yes, they are. Look at, for example, a revocable living trust. That is a self-settled trust. You've created it, you funded it, and you are a beneficiary of the trust itself. Is it protective? Under common law, I think Barry mentioned this earlier, no. That is, under common law principles, you couldn't create a trust, fund it, be a beneficiary, and still protect those assets from your creditors. But it's still a valid trust, regardless of those circumstances. Now,
Can I ask a quick question?
Sure.
I know sometimes courts speak in terms of illegal trusts, self-settled trusts as illegal trusts. And in fact, one of the recent cases, one I have here, I won't bother, but it speaks in, maybe it was the Huber case.
Was it the Huber?
It spoke in terms of an illegal trust. Is a self-settled trust, is a revocable living trust illegal? Is a trustee IRA illegal? Is a qualified plan trust or a QPERT illegal because it's self-settled?
No, and that's where you run into occasional judges, I hate to say, who aren't up to speed on trust law, up to speed on a lot of things I'm not up to speed on, but maybe not trust law, and sometimes they throw around terms they shouldn't be throwing around. They may say, well, this trust isn't valid. Well, of course it's valid. As you brought up the example, it's not just a revocable living trust, but a QPERT or an IRA if it's in the form of a trust. Those are things that are self-settled, that you remain the beneficiary. They're obviously valid, and the fact that they may or may not protect assets from a creditor has nothing to do with their validity. It may have to do with whether the creditor can get to the assets, but the trust is valid one way or another. And in fact, I'll make two distinctions. One is under common law in the Isle of Man, they have developed common law that is protective in those situations for self-settled trusts. And years ago, our firm used to use the law of the Isle of Man as a jurisdiction in which to create trusts that protected the assets for the creditor for the settler / beneficiary from the settler's creditors. But then,
and we still do.
And still do. But then, and you're going to have to help me with the year on this, but I know back, again, 89, was it 89 when you got together with a barrister down in the Cook Islands and helped fashion the first really comprehensive statute that was focused on asset protection. So now, not only do we use the Cook Islands a lot and have been helpful in evolving that statute as the years have gone by, but a number of foreign jurisdictions have also, whether using the Cook Islands as a model or coming up with their own model, have passed asset protection type of statutes for just that purpose. That is, you can create a trust, you can fund it, you can be a beneficiary, but those assets will be protected from your creditors if you do it in the correct manner. And